Under Article 128, the law punishes violation of domicile. Violation of domicile under Article 128 is committed when the following elements are present. First, that the offender is a public officer or employee. Second, that the offender is not authorized by judicial order to enter the dwelling of another. And lastly, that he enters the dwelling of another under any of the following circumstances. First, when the entry is done against the will of the owner. Second, when he searches papers and effects found therein without the previous consent of the owner. And lastly, when after having surreptitiously entered the dwelling of another, being ordered to leave, he refused to leave. These are the elements of violation of domicile under Article 128. The offender is based on the first and second element. The offender is a public officer. He is not authorized by a judicial order to enter the dwelling of another. Therefore, the offender is a public officer acting under color of authority. A public officer, insofar as violation of domicile is concerned, is said to be acting under color of authority when he is one who is authorized by law to implement and serve the search warrant, but at the time he entered the dwelling of another and searched the said place, he is not armed with a search warrant. He is not armed by a judicial order to enter the place. Hence, he is acting under color of authority. The last element of violation of domicile provides for the modes of committing the crime. First, by entering the dwelling of another against the will of the latter. When you say the entry is against the will of the owner, it means that there is a prohibition. There is a prohibition for the said public officer to enter. There is a prohibition or opposition, and this prohibition or opposition can either be an implied or expressed opposition or prohibition. The moment the door of the house is closed, even though it is not locked, that is an implied opposition or prohibition to enter. When there is a note at the door of the house, no entry, no one may enter, that is an example of an express opposition, express prohibition to enter. The second mode is by searching papers and effects found therein without the previous consent of the owner. Even if a public officer is allowed by the owner of the house to enter his dwelling, that does not necessarily follow he is also allowed to conduct with the search. The permission is only to enter the dwelling, but before he proceed with the search, since he is not armed with a search warrant, he must seek the previous consent of the owner. If the owner would not allow him to conduct the search, then he should leave. If he proceeded with a search without the previous consent of the owner, he becomes liable for violation of domicile. And under the last act, after having surreptitiously entered the dwelling of another, being ordered to leave, he refused to leave. When you say surreptitious entry, it means the entry was done secretly. The entry was done without the consent of the owner thereof. It is not upon the surreptitious entry that the crime will arise. It is upon his refusal to leave when he was ordered to leave after making a surreptitious entry that the crime will arise. So it is on his refusal to leave the said premises upon being ordered to leave. And so far as Article 128 violation of domicile is concerned, the penalty is qualified if the crime of violation of domicile is committed in the night time, or if any papers and effects not constituting evidence of the crime has not been returned by the peace officer to the owner thereof immediately after the search. Any of these two circumstances will qualify the imposable penalty. The barangay chairman and two members of the Coup entered the house of W about 12 o'clock midnight. W at that time was already fast asleep, but W heard some noise in the sala of his house. And so W got out of bed, went to the sala, and there he saw the barangay chairman at their place and two members of the Coup. They were searching his house. He asked why they were there, but he got no response. He asked them to produce the search warrant, but also they got no response. They just continued searching everywhere until they opened one cabinet and they saw a shotgun. The barangay chairman, as well as the Coup, took the said shotgun and thereafter left. What further crimes had been committed by this barangay chairman and members of the Coup? They were convicted after the Court of Appeals of the crime of violation of domicile. When the case reached the Supreme Court affirmed the conviction for violation of domicile, but the Supreme Court said the RTC and the CA failed to consider the qualifying circumstances that it took place at night time, 12 o'clock in the evening, and the shotgun, which does not constitute as evidence of the crime, was not returned immediately to the owner W thereof. So the Supreme Court increased the imposable penalty because of the presence of these two qualifying circumstances. The police officer wanted to search the house of X, but they have no sufficient evidence, although they know, based on rumors, that X was involved in drug peddling, drug sale. They were trying to get evidence so that they could apply for a search warrant, but they could not get any from the outside. So one time, these two police officers, believing that no one was inside the house, they tried to open the door. And they realized, although the door of the house was closed, it was not locked. And so these two police officers opened the said door and entered inside. Thereafter, they look at the sala and they believe that they should go first upstairs to look for any evidence regarding the sale of drugs. When they went up the stairs, upon getting up the stairs, they immediately saw the owner who was about to go down the stairs. And the owner, upon seeing the police officers, shouted angrily, "Who are you? Why are you here? You get out of my place. You have no business in my house." And the police officers, since they were discovered by the owner thereof, immediately left the place. But the owner consulted his counsel, and the counsel filed a case of violation of domicile against the said public officers. Are the public officers liable as charged for violation of domicile? They are public officers. These are two police officers. They are not armed with a judicial order. They are not armed with a search warrant. They had not yet applied for a search warrant when they entered the dwelling. And they entered the dwelling against the will of the owner. The first act has been violated. There is an implied opposition or prohibition to enter because the door was closed, although it was not locked. They are prohibited from entering when they entered, even if they left when they were discovered in order to leave. The mere fact that they entered despite the implied prohibition and their intention is to conduct a search, they're already liable for violation of domicile under Article 128. Under Article 128, a public officer is liable for violation of domicile because in entering the place of another, he is not armed with a search warrant. There are, however, instances wherein a public officer still becomes liable for violation of domicile even if he is armed with a search warrant. And they are those provided for under Article 129 and 130. Under Article 129, in the following instances, violation of domicile is still committed by a public officer even if he is armed with a search warrant. First, when the search warrant is maliciously procured, that is, the search warrant is procured without just cause. Second, when the public officer exceeded the authority in the search warrant. Or third, when the public officer employed unnecessary severity in the implementation of the search warrant. These are the acts constituting violation of domicile under Article 129. Under Article 130, violation of domicile is also committed when the said public officer, armed with a search warrant, proceeded with the conduct of the search in the absence of the owner of the house or any member of his family or any two persons residing in the same locality. So all in all, there are 4 instances under Articles 129 and 130 wherein a public officer can become liable for violation of domicile even if he is armed with a search warrant. The first is when a search warrant was maliciously procured. The search warrant was procured without just cause. Before a search warrant the requisites for the valid issuance of a search warrant are first, the search warrant is for one specific offense. Second, there must exist probable cause. Third, the probable cause must be determined personally by the issuing judge. Fourth, the determination of the said probable cause personally by the issuing judge must be done under oath through searching questions and answers made before the applicant of the said search warrant and his witnesses. Fifth, the applicant for the search warrant and the witnesses must testify only as to facts personally known to them. And lastly, the search warrant must specify the place to be searched and the things or persons to be seized. These are the requisites for the valid issuance of a search warrant. If any of this is wanting, the search warrant was procured without just cause. And if they are armed with a said search warrant and proceeded with a search, then they committed violation of domicile. Under the second act, when the public officer exceeded the authority in the said search warrant, Supreme Court said, a search warrant is so specifically worded in detail because police officers, public officers, are not allowed to exercise discretion in the implementation of the said search warrant. They must follow the said search warrant. And lastly, when the public officer employed excessive severity in the implementation of the search warrant. After any search, police officers have this document. They have this affidavit of orderly search, because they are required by law to conduct the search in an orderly manner. They must not employ excessive severity. If they do so, they become liable for violation of domicile under Article 129. And under Article 130, the Article 130 as well as the rules of court provides for an hierarchy of witnesses who must be present in the conduct of the search. Under Article 130 and the rules of court, the search must be witnessed by the owner of the house if he is present. In his absence, the search must be witnessed by any member of his family. And if both the owner or any member of the family would be absent, then there must be at least 2 representatives coming from the same barangay. These are the hierarchy of the witnesses who must be present during the conduct of the search to be done by the said peace officers. The police officer had been conducting surveillance on X because he heard from news that X had many firearms inside the house. However, he has been conducting surveillance for a week. He could not find evidence. There was already he has been there morning and night trying to look for evidence if indeed there were firearms and licensed firearms inside. He could not find evidence. But he really wanted to search the house. And so he went to the court and he applied for a search warrant. And in his application for search warrant, in answering the questions of the said judge under oath, when he was asked how sure he was that there was search warrant, he said that he was very positive that there was search warrant because he observed men bringing guns from their car inside the said house. And after making some other stories of the said presence of guns inside the house of this person, let's say the person is W, the judge believed the said police officer, and so the judge issued the said search warrant against W. Police officer X now and his men were armed with a search warrant, and they went to the house of W, serving the said search warrant. W at first questioned it because W knew he has no gun inside. There is nothing inside. He is not engaged in gun smuggling or anything. But because of this search warrant, he respected it. It comes from the judge. He allowed. And the police officers proceeded with the conduct of the search. And they did not find any of the said loose firearms. But W was so embarrassed in the community. It was an embarrassing, a shameful act done inside his house. And so, he wanted remedies. He went to his counsel. He wanted to file case against the said police officers. What cases may he file against the said police officers? W may file the following cases. First, W may file a case of violation of domicile under Article 129. The search was done armed with a search warrant which is illegally procured. It was a maliciously procured search warrant. And second, he can also file a case of perjury against the said police officer who applied for the search warrant. The said police officer perjured himself in telling the court under oath that he is positive, based on surveillance, that he saw guns being boarded inside the said house. He perjured himself, it was done under oath, and therefore he becomes liable of these two crimes. Even if the perjury was a necessary means to commit violation of domicile, you cannot complex the two. Because under Article 129, the law expressly provides that the liability for violation of domicile shall be in addition for any liability arising for the commission of any other crime. So since aside from violation of domicile, he committed another crime, it will constitute a separate and distinct charge. So two cases may be filed by W against police officer X. That is, violation of domicile under Article 129 and also perjury. The police officers received the search warrant from the court. It was dated July 1. The police officers in the place were so busy. And because of this, they were able to serve the said search warrant against X on July 15. July 15, they served the said search warrant. They proceeded with the conduct of the search, and in the search warrant, they are commanded to look for 2 caliber 45 pistols inside the said house. In the search, inside a big box, wrapped in plastic and in newspaper, the said police officers indeed found these 2 unlicensed caliber 45 pistols. And thereafter, they brought it and they filed a case against the said person of X. They filed a case of illegal possession of loose firearms. But X filed a countercharge. X filed a case of violation of domicile. And he also moved that these 2 firearms taken from his house were inadmissible in evidence in the case of illegal possession of loose firearms filed against him. Are the police officers liable for violation of domicile? Are the firearms seized and confiscated by them inadmissible in evidence in the case of illegal possession of loose firearms filed against him? The police officers are liable for violation of domicile. The police officers exceeded the authority in the search warrant, a prohibited act under Article 129. The search warrant was dated July 1. It was issued July 1. Therefore, they have only 10 days within which to serve the said search warrant. A search warrant is valid only for a period of 10 days from the date of its issuance, that is, from the date appearing on the face of the said search warrant. Since they served the search warrant July 15, it is way beyond the 10-day period. Therefore, it is as if they are conducting the search without a search warrant because it is an expired search warrant. Hence, they are liable for violation of domicile. They exceeded the authority in the said search warrant. The 2 caliber 45 pistols, which are unlicensed, found would be inadmissible in evidence in the case of illegal possession of loose firearms, because they are considered as fruits of poisonous tree, as they were seized and confiscated based on an illegal search on the part of the said police officers. The police officers were armed with a search warrant against W. And the police officers went to the house of W. The search warrant stated that they are commanded to search the house of W located in this place, and they are required to search for loose firearms inside the said house, and the loose firearms were specifically stated. That was the command in the said search warrant. Based on their surveillance, W is always outside the house, and he always comes home about 10 in the evening. Therefore, in order to ensure that he is inside the house, they went to the house of W to serve the search warrant at exactly 12 o'clock midnight. And true enough, W was there, W was fast asleep, they knocked at the door, W opened the door, they served the search warrant to W. There were many police officers because this involved guns, and W might put up a fight, so there were about 20 police officers who wanted to conduct a search warrant. The house of W was a small one. W opened the small door for them to enter. And the police officers entered. But they were so excited to enter that anyone could enter passing through the door. They broke open the window and entered also through the window. Inside the house, they searched each and every appliances, each and every furniture. They turned upside down without considering if there is damage. They seem to be deliberately damaging everything inside the house. And indeed, they were damaged. But, lucky for them, they indeed found many loose firearms inside a cabinet. Thereafter, they brought the same to the said police station, and they filed a case of illegal possession of firearms against W. W wanted to file a countercharge. Can he file any? He can file a case of violation of domicile. What acts of violation of domicile had been committed by the said police officer? First, the police officers exceeded the authority in the search warrant. The search warrant merely commanded them to make a search. But the search warrant didn't specifically state the time. Since the search warrant didn't specifically state the time, under the rules of court, the said search must be done only during daytime. A search warrant may be served only during daytime except when there is express statement in the search warrant that it can be served at any time of the day or night. There is no such statement in the search warrant, and they served it at night time, 12 o'clock. Therefore, they exceeded the authority in the said search warrant. The police officers also employed excessive severity. Under the rules of court, a peace officer may only break open any house if he is denied entry, despite service of search warrant. Here, the police officers were not denied entry. They were allowed to enter. But still, they entered, breaking the window, and once inside, they break the appliances in the conduct of the search. Therefore, they employed excessive severity in the implementation of the said search warrant. Hence, they are liable for violation of domicile under Article 129. In addition to that, since the police officers deliberately break these appliances, the police officers are also liable for malicious mischief. The act of deliberately causing damage to the property of another amounts to malicious mischief under Article 327. And as stated under Article 129, the two cannot be complex, although the breaking of the said furnitures and appliances were really manifestation of the employment of excessive severity. They cannot be complex. They must be charged as two separate and distinct cases. The loose firearms no matter how many they are, would be inadmissible in evidence in the case of illegal possession of loose firearms filed against W because they were seized and confiscated through an illegal search. Hence, they are inadmissible in evidence being fruits of poisonous trade. The police officers were armed with a search warrant. They went to the house of X, 9 o'clock in the morning. They served the search warrant to X. X cannot do anything but allow them to enter. Here is a search warrant, validly issued by the court. And so the police officers entered the place. It was quite a big house. And the police officer asked X, "We are first to proceed to conduct the search in your bedroom. Where is your bedroom?" And X pointed his bedroom, which was located on the second floor of the house. Thereafter, the police officer gathered X, his wife, his children, his parents, and told them all to sit in the kitchen, on the chair in the dining table. "You stay here. We will do the search inside your bedroom. The search will be witnessed by these 2 barangay councilors whom we brought along." And so the police officers proceeded with the conduct of the search in the bedroom of X in the presence of the said two barangay officials. And indeed, after looking in the conduct of the search, they were able to find the said loose firearms that were stated in the said search warrant, commanding them to seize and confiscate. So they seized and confiscated the same. And they filed a case of illegal possession of loose firearms against X. X wanted to file a case against them. What case may X file against said police officers? X may file a case of violation of domicile under Article 130. The search was conducted in the absence of the owner of the house, under Article 130 and under the rules of court. If the said owner of the house is present, he must be the witness to the conduct of the search. It is only in his absence or in the absence of any member of the family that the search may be witnessed by 2 persons coming from the same locality. There is no need for barangay officials in the conduct of the search the moment the owner or any member of his family is present. There is only a need for this elected official if what is being searched is shabu, what is being searched is dangerous drugs, because it is expressly required under Section 21 of RA 9165. But if the things to be searched is not that of dangerous drugs, there is no need to bring any elected public official. The presence of the search must be conducted in the presence of the owner or any member of his family. Since the search was the product, the guns were seized and confiscated based on a local search, it would be again inadmissible in evidence. So those are the instances wherein a peace officer can still be held liable for violation of domicile even if he is armed with a search warrant issued by the court under Articles 129 and 130. Under Article 131, prohibition, interruption, and dissolution of peaceful meetings. The elements of prohibition, interruption, and dissolution of peaceful meetings are, first, the offender is a public officer or employee that he commits any of the following acts: prohibiting, interrupting, or dissolving without legal ground the holding of a peaceful meeting, or by prohibiting or hindering any person from joining any local association or from attending any peace meeting, or by prohibiting or hindering any person from addressing, either alone or together with others, any petition to the government for collection of abuses or redress of grievances. These are the elements of Article 131. Again, the offender is a public officer or employee. It is necessary that the peaceful meeting that has been dissolved or interrupted must not be for legal ground. These 3 acts in Article 131, if committed by a public officer, is considered as criminal in nature because they are in violation of the Bill of Rights. They are in violation of the rights enshrined in the 1987 Constitution. Hence, If committed, if any peace officer prevented anyone, any group from exercising these rights, then they become criminally liable under Article 131. Under Article 132, the law punishes interruption of religious worship. Interruption of religious worship is committed when, again, the offender is a public officer or employee. That there is a religious ceremony or manifestation of any religion that is ongoing or about to take place, and the offender prevents, interrupts, or disturbs the said religious ceremony or manifestation of any religion. The penalty is qualified if the crime is attended, if the commission of the crime is attended by violence or threats. So the presence of violence or threats would qualify the imposable penalty in case of interruption of religious worship. So it is necessary that what is being interrupted is a religious ceremony or a manifestation of any religion that is ongoing or about to take place. And then we have the last one under Article 133, that is offending religious feelings. Offending religious feelings is committed when the following elements are present. First, the offender is any person. Second, that he performed acts notoriously offensive to the feelings of the faithful. And lastly, the said acts were performed either during a religious ceremony or in a place dedicated to religious worship. Article 133, offending religious feelings, is the only felony under Title 2, wherein the offender is any person. From Articles 124 to 132, the offender is always a public officer or employee, because Title 2 is crimes against the fundamental law of the state, crimes against the Constitution. Under Article 133, however, the offender may be any person. He can be a public officer or employee, he can be a private individual. And he performed acts notoriously offensive to the feelings of the faithful. Acts are said to be offensive to the feelings of the faithful when they are directed to the belief, religion, to the belief, practice, or dogma of any particular religion, or there is an attempt to cause damage on the object of veneration of a particular religion. It is said to be notoriously offensive when the said act is offensive not only to one particular religion, but to all kinds of religion, if the same act is done on them. And where should the act be performed? The act should be performed either during a religious ceremony or in a place dedicated to religious worship. Last question, 2017 bar exam. There was a mass, and the priest was saying the homily, and in the said homily, the priest related the gospel to the extrajudicial killings happening in the Philippines. And the priest attacked the men in uniform for all these extrajudicial killings. And among those in attendance in the said mass was Police Officer X. Police Officer X was so offended by this attack in the homily made by the priest against men in uniform. He stood up from his seat. He went to the police officer. Showing the service pistol tucked on his waist, he told the police officer, he told the priest, tumigil po kayo, kung hindi may pagkakalagyan kayo. Showing the pistol tucked on his waist. The priest became so afraid. It means he would be killed. He saw the gun there, and so the priest stopped. He stopped the homily, he left the altar. The members of the congregation inside left. The mass ended. The question in the bar, is the said police officer liable for interruption of religious worship under Article 132? Or is the said police officer liable under Article 133, offending religious feelings? 8 points. 8%. Ang laki. Isipin ko, 2 points lang. Ang laki sa ko, bakit 8 points to? Siguro, katapusan na yung question niya, 8 points na lang ang kulang sa 100 points. Is the said police officer liable We go first to the second question. Is a said police officer liable for offending religious feelings? The police officer is not liable for offending religious feelings under Article 133. The act done by the police officer did not attack the dogma, the practice of the Catholic religion. And even if the same act is done on any other religion, it is not an attack on their dogma, on their practice, on their belief. Therefore, it is not offending religious feelings. The second element is absent. Is it interruption of religious worship? Yes, it is interruption of religious worship. The offender is a public officer. There is a religious ceremony or manifestation of a religion that is ongoing. The Mass is a manifestation of the religion of the Catholics. And the said public officer prevented, disturbed the said religious ceremony or manifestation of any religion. His act of showing the pistol prevented the said prohibited, prevented, disturbed the said priest from going on with the said Mass, and he stopped in the homily. All the elements are present. Now, there is the presence of threats. Because by merely showing the gun, by merely threatening the priest with the said gun, there is threat. It amounted, in fact, to other light threats under Article 285. But will it give rise to a separate and distinct charge of other light threats? The answer is no, because under Article 132, the presence of such threats or violence will only qualify the imposable penalty. We now go to Title 3, Crimes Against Public Order. Title 3, Crimes Against Public Order. The first among these, under Article 134, we have rebellion. Rebellion is committed when the following elements are present. First, that the offenders that there be public uprising and taking up of arms against the government. And second, the purpose of the uprising or movement is to attain any of the following. First, to remove from the allegiance from the Philippine government or its laws, the territory of the Philippines or any part thereof, or any body of land, naval, or other armed forces. Or, to deprive the Chief Executive or Congress, wholly or partially, of any of their powers or prerogatives. These are the elements of rebellion. Based on the elements of rebellion, its essence is an armed public uprising. The public uprising must be coupled with taking up of arms against the government and for the purposes I mentioned. How about coup d'etat? Under Article 134A, coup d'etat is committed when any person who belongs to the military, the police, or those holding public office or employment with or without civilian support commits a swift attack accompanied by violence, intimidation, threat, strategy, or stealth, directed at the duly constituted authorities of the Republic of the Philippines, military camp or installations, reservations, communication facilities, or other utilities which are needed for the exercise and continued possession of powers carried out singly or simultaneously anywhere in the Philippines for the purpose of seizing or diminishing state powers. That is coup d'etat. Based on its elements, based on the way of committing coup d'etat, the essence of coup d'etat is a swift attack against the duly constituted authorities, communication networks, public utilities. So the following are the distinctions. Rebellion versus coup d'etat. First, in rebellion, the essence is an armed public uprising. The public uprising being coupled with taking up of arms. Whereas, in coup d'etat, the essence is a swift attack against the duly constituted authorities. Second distinction, rebellion involves a multitude of people. There must be the participation of the civilian. Supreme Court said it is akin to a civil war, it is a crime of the masses. Whereas, coup d'etat only requires that it be committed by any member of the military, the police, or any public officer or employee with or without civilian support. So civilian support is not material in case of coup d'etat. Third distinction, the objective of rebellion is to overthrow the government and to replace it with the government of the rebels. Whereas the objective of coup d'etat is not to overthrow the government but to diminish state power. And lastly, rebellion can be committed only by means of force and violence because it requires the presence of arms. Whereas coup d'etat may be committed not only by means of force and violence but also through strategy, intimidation, stealth, etc. So those are the distinctions, rebellion versus coup d'etat. In cases of rebellion and in cases of coup d'etat, there is the so-called theory of absorption in rebellion, theory of absorption in coup d'etat. And based on this so-called theory of absorption in rebellion, theory of absorption in coup d'etat, if in the course of the commission of rebellion, if in the course of the commission of coup d'etat, the participant therein shall commit common crimes in furtherance of, incident to, or in connection with rebellion or coup d'etat, the commission of these common crimes are absorbed in the crime of rebellion, in the crime of coup d'etat. Therefore, they will not constitute separate and distinct charge. However, before this theory of absorption in rebellion and coup d'etat may apply, it is necessary that there must be evidence showing in what way the commission of the common crimes has espoused or fostered or promoted the ideals of the said rebels. Because it is necessary that the common crimes were committed in furtherance of, incident to, or in connection with rebellion or coup d'etat. Otherwise, it will constitute a separate and distinct charge. X was a participant in the rebellion. There was this rebellion ongoing in the Philippines, in the entire Philippines, in Metro Manila, in different provinces. There were public uprisings against the government. They wanted to topple down the government and replace it with the government of the rebels. And X was a participant therein. He is participating in this public uprising here in Metro Manila. While he was there, publicly uprising, he saw Y pass by. He was mad at Y. Prior to the public uprising, he and his men approached Y, encouraging Y to join them. But Y was pro-administration, and Y did not join. X was so mad at Y, X ran towards Y, and thereafter he stabbed Y to death. The police officer ran after X. While X was running from the police officer who was trying to chase him, here comes W, another participant in the public uprising in the said rebellion. W saw X running. W called on X, signaled X to follow him. And X followed W and both went to a hiding place unknown to the police. The police could not locate X and W. After several months, finally, the police officers were able to locate X and W. And they were both arrested and they were both charged in court. X was charged with rebellion and also homicide, whereas W was charged with rebellion for participating in the said rebellion and also with a crime of violation of PD 1826, that is, obstruction of justice, because he hid and concealed X. Are they liable as charged? Are the charges correct? Insofar as X is concerned, the crime charge or the crime he committed should only be rebellion. The homicide is absorbed under the so-called theory of absorption in rebellion. The said act of killing Y was done by X in furtherance of incident to or in connection with rebellion. How about insofar as W is concerned? W was also a participant in the rebellion who hid X. W should also be charged only of one crime, and that is rebellion. PD 1826, his act of concealing X was done in furtherance of incident to or in connection with rebellion. Therefore, it is also absorbed under the so-called theory of absorption in rebellion. Supreme Court said, the theory of absorption in rebellion does not only involve common crimes. It also includes violation of special penal laws, if the violation of the special penal laws was done in furtherance of, incident to, or in connection with rebellion. And here, W's act of hiding X was done in furtherance, incident to, or in connection with rebellion. Therefore, it is also absorbed under the so-called theory of absorption. The theory of absorption, however, the members of the military who staged a coup d'etat against the government were arrested, and these members of the military were charged of two crimes. They were charged of coup d'etat before the RTC, and they were charged of violation of the Articles of War before the military court. They filed a motion before the RTC saying that the said hearing of the case before the military court for violation of the Articles of War should be stopped as it is already absorbed in the crime of coup d'etat. If you were the judge, would you grant the said motion? If you were the judge, you have to deny the motion. Violation of the Articles of War cannot be absorbed by coup d'etat based on the theory of absorption. Supreme Court said the theory of absorption in rebellion and coup d'etat would only lie if the crimes committed in furtherance of rebellion are within the jurisdiction of the same court. Here, coup d'etat and violation of the Articles of War are not within the jurisdiction of the same court. Violation of the Articles of War would be outside the jurisdiction of any civilian court. It can only be heard by a military court. Hence, it cannot be absorbed by coup d'etat based on the theory of absorption. There was this armed encounter in Lanao. There was armed encounter between members of the military and the members of the NPA. It wasn't an ambush, it was a legitimate armed encounter. Both of them were patrolling the area when suddenly both groups saw each other and they exchanged gunfires at each other. In the said exchange of gunfires against one another, two members of the military, two officers of the military died. Others were fatally wounded, but they survived when brought to the hospital and operation was immediately performed. These members of the NPA who was engaged in the said chance encounter were all arrested. Brought to the fiscal's office, they were charged with a crime of double murder and multiple frustrated murder. And they filed a counter affidavit. In their counter affidavit, the members of the NPA stated that they should be charged with only one crime. They should be charged only with rebellion. Because according to them, it was not an ambush. It was a legitimate chance encounter, armed encounter between two groups. Hence, it is an act of rebellion and not considered as murder and multiple frustrated murder. Despite their allegation, their arguments in the counter affidavit, the fiscal, the Office of the Public Prosecutor, filed a case of murder and multiple frustrated murder before the RTC. And so the Council of the NPAs filed a motion to quash. But the RTC denied the motion to quash. The case went to the Supreme Court. Are the charges correct? Or should the said members of the NPA be charged with only one crime, and that is rebellion? Supreme Court said the charges are correct. It should not be rebellion. Supreme Court said the theory of absorption of rebellion has yet no basis. Here, the proceeding is still in the arraignment stage, in the initial stage. Since the proceeding is still in the initial stage, no evidence had yet been presented before the court to show in what way the said act of killing has promoted, has fostered the ideals of the rebel group NPA. Therefore, absent such evidence, it cannot be said that the said act of killing was done in furtherance of, incident to, or in connection with rebellion. Therefore, the appropriate charge would still be murder and multiple frustrated murder. The Supreme Court further discussed. Supreme Court said, if in the course of the hearing, upon presentation of the defense evidence, the defense was able to prove that the said act of killing the said military men was done in furtherance of or incident to rebellion, then what the fiscal should do is to withdraw the case of murder and multiple frustrated murder and file a new case, a new information for rebellion to conform with the evidence. Supreme Court said that is what should be done, but at first, the case should be murder and multiple frustrated murder. What about sedition? How is sedition committed under Article 139? Under Article 139, sedition is committed when the following elements are present. First, that the offenders rise publicly and tumultuously, that they employ violence, intimidation, or any other means outside the legal method. And lastly, the purpose of the offender is to attain any of the following. First, to prevent the promulgation or execution of any law or the holding of a popular election, or to prevent the national government, provincial or municipal government, or any public officer from freely exercising its or his function, or to prevent the execution of an administrative order, or to inflict any act of hate or revenge against the person or property of a public officer or employee, or to commit for any political or social end any act of hate or revenge against private persons or social class. And lastly, to despoil for any political or social end any person, municipality, province, or the national government of all its property or any part thereof. These are the elements of sedition. In sedition, just like in rebellion, there must be public uprising. However, unlike rebellion, in sedition, the said public uprising is not coupled with taking up of arms. In sedition, the use of arms is not required. It suffices that the said public uprising be done tumultuously, carried outside the legal methods, employing violence, employing intimidation, or any other means outside the legal method. They also differ in purposes. In so far as rebellion is concerned, the objective, the purpose is always political in nature, that is, to overthrow the government. Whereas, in case of sedition, the objective can either be political or social in nature. It is not to overthrow the government, but to prevent the government from enforcing, implementing, executing something. Or it is an act of hate or revenge against any public officer or employee. What if there is this, before that, there is such a crime as conspiracy to commit rebellion? There is such a crime as conspiracy to commit coup d'etat? There is such a crime as conspiracy to commit sedition. There is a crime as proposal to commit rebellion. There is a crime as proposal to commit coup d'etat. But there is no such crime as proposal to commit sedition. Proposal to commit sedition is not a punishable act under the RPC. There is such a crime as inciting to rebellion. There is such a crime as inciting to sedition. But there is no such crime as inciting to coup d'etat. Inciting to coup d'etat is not a punishable act under the RPC. Inciting to rebellion, inciting to sedition, can be committed only by persons who are not participants in the ongoing rebellion or sedition. Inciting to rebellion is committed when the offender is not in open hostility with the government, not a participant in the rebellion. And yet, the said offender incites others to uprise publicly for any purposes of rebellion. And the inciting is done by means of speeches, proclamations, emblems, banners, or any other representations tending towards the same end. That inciting to sedition is committed in the same manner. The offender is not a participant to any sedition, yet he incites others to rise publicly for any of the purposes of sedition. And again, the inciting is done by means of speeches, proclamations, writing, emblems, banners, cartoons, or any other presentations tending toward the same end. The offender in inciting to rebellion, inciting to sedition, must not be a participant, must not be a party to the ongoing rebellion or sedition. Because if he is a party therein, the appropriate charge is rebellion or sedition, as the case may be, and not merely inciting to rebellion or inciting to sedition. There is a rebellion ongoing. X was a participant in the said rebellion. X was arrested by the police officers. X was found in possession of a loose firearm, an unlicensed firearm, not registered. And so, the police officers filed 2 cases against him. One is rebellion, and the other one is illegal possession of loose firearms. Are the charges correct? The charges are wrong. It should only be rebellion. The use of the loose firearm is absurd. There is an attempted coup d'etat ongoing. Although X is a civilian, he sympathized with the military. And so X participated in the said attempted coup d'etat. He was arrested and he was caught in possession of a loose firearms. He was charged of 2 cases, attempted coup d'etat and illegal possession of loose firearms. Are the charges correct? The charges are wrong. It should only be attempted coup d'etat, and the use of the loose firearm is absurd. There is a seditious rally ongoing. They are against the promulgation of a new law. And so there was the seditious rally ongoing carried out by means of violence. Among the participants was X. X was arrested. And when he was frisked, he was found in possession of a loose firearm. And so he was charged of 2 cases. One is sedition, and the other one is illegal possession of loose firearms. Are the charges correct? The charges are correct. Under the new firearm law, RA 10591, under Section 29, second paragraph, the law provides that if the use of the loose firearm is in furtherance of, incident to, or in connection with rebellion or insurrection or attempted coup d'etat, it is deemed absurd in the crime of rebellion or insurrection or attempted coup d'etat. If you will notice, under the former law, PD 1866 as amended by RA 8429, this includes sedition. But in this new law on firearms, sedition has been deleted as among the crimes that will absorb illegal possession of loose firearms. So now, based on Section 29 of the said law, only rebellion or insurrection and attempted coup d'etat would absorb the use of a loose firearm if the use of the loose firearm is in furtherance of, incident to, or in connection with rebellion or attempted coup d'etat. Sedition no longer absorbs illegal possession of loose firearm. So if a participant to a seditious rally is found in possession of a loose firearm, what you consider is either the first paragraph of Section 29 or the last paragraph of Section 29. The first paragraph provides that if the use of a loose firearm is inherent in the commission of the crime, it is considered as an aggravating circumstance. Last paragraph, if the use of a loose firearm is not inherent in the commission of the crime, it shall constitute a separate and distinct charge. In the crime of sedition, the use of a loose firearm is not inherent because the law only requires that the public uprising be done tumultuously. It is not required that the public uprising be coupled with taking up of arms. Therefore, it will give rise to 2 cases. One is sedition and the other one is illegal possession of loose firearms. You have your lunch break. I will continue this after.